question and answers. To deliberate and enlighten us on today's topic, we are joined with three experts on ADR and IBC. First, we have Mr. Yash Malik, former Executive Director of ONGC and IICA certified mediator. Further, he is the former advisor at Ministry of Petroleum and Natural Gas. Next, we have Mr. Sarvesh Kashyap, advocate and insolvency professional and IICA certified mediator, having experience of more than 2 decades in the field of corporate laws and matters pertaining to IBC.
Thank you, Kritika.
Last but not the least, we have Mr. Samir Rastogi, managing partner at India Juris with more than 25 years of experience.
Thank you, Kritika. It's always a pleasure to be on this webinar.
The participants may drop their queries in the chat box. Now, I would like to invite Mr. Malik to share valuable insights on mediation in the oil and gas sector.
Good afternoon, all. I hope I'm audible.
Yes, Malik ji, you are
Yes, sir, you are audible.
Okay, thank you. Mediation per se, first time effort has been made in oil and gas industry. Our government is the biggest litigator, we all know. And the industry, and in fact, maybe all industries where government has the control, there are a lot of litigations. And in oil and gas industry, there were a lot of production sharing contracts which were allotted by government right from 1990 onwards. But many of them went under litigation soon after their allotment for various reasons. Unfortunately, not much of progress could be made in the exploration and production front in India, in oil and gas, we all know. And the reason was that most of the blocks were under some or the other litigation, and there were no easy solutions. And then probably in 2019, government thought of making a committee. They called it CEEE, Committee of External Eminent Experts, in which the Secretary Petroleum, erstwhile Secretary Petroleum, Chairman, ex-Chairman ONGC, and one more expert was there. Now, the purpose was to take it forward under conciliation, because in 2019, Mediation Act had not come. It was then the Arbitration and Conciliation Act 2016. And under Section 73, the mediation started. Now, the purpose was to have a clear communication with the consent is taken from the parties, whoever wanted to go ahead with conciliation. And there were about 64 contracts at that point. Almost 50% of them got resolved because of this. And although it has taken a very long time, 2019, the committee was set up. They had their first meeting in 2022. There was COVID period, and now in 2024, more than half of the contracts got resolved. Now, I would like to say that there was a huge money involved, and I think government got around $180 million, plus all the contracts got operational. So in a way, it has given a boost to to the sector. And now what I understand, there is an order from the Finance Ministry. Now the mediation will happen under the Mediation Act for the new blocks wherever issues have to be resolved. So mediation will come as a big boon to the industry for resolving the long pending issues. You see, I'll tell you, there were, in our business and in government, if you have written something in contract, going beyond it is a big no. Nobody likes to plunge into that area. And now, but with the Mediation Act, now it also, covers your back. Under Section 50, anybody, any government servant who's doing mediation, he is not, he is covered by any kind of legal or for those agencies. So it is easy to take decision, although if any corrupt practice happens during mediation, that will be separately taken care of. So in this particular case, lot of spade work was done. All the issues, there were 64 blocks. All the issues what were there were enlisted. Then the principles were made as to how to resolve the issues. They were discussed with the stakeholders, and many of the issues were of the nature, although they were in the contract, but they were not practically feasible. So they were all waived off, and so that gave everybody, like geological, we have geological, in the minimum work program in oil and gas industry, you have to drill certain wells and you have to do some exploration. Now, many times clearances were not given, so the parties couldn't do anything. Say, like even while drilling, if in the tender they had said we'll drill 3,000 meters, but if the geological objective was met in 2,000 meters, there was no point in drilling 3,000 meters. But then there were huge penalties for that. So later on, sense prevailed, and in mediation, what was technically correct and what was feasible, and if clearance was not there, so there were a lot of waivers which were given in mediation, and finally, out of 64 blocks, more than 50% of the blocks, the issues got resolved. That's all from my side, Kritika. Hello, can you hear me?
Yes,
Thank you so much,
Samir, please unmute yourself.
Yeah,
Mr.
yeah.
Yash
So
Malik,
Pratika, I have few
for
things.
sharing your valuable insight on mediation. So,
So Pratika, I have few things to ask to
yes,
Mr.
sir, please add some
Malikji
more to
before we
this.
proceed forward. Sir, you have been associated with ONGC, and you have in-depth knowledge about oil and gas sector. So being a certified mediator, we are taught that you don't require any specific knowledge. Do you think for a mediation in oil and gas sector, you require specifically you need to have the knowledge of oil and gas sector, without which you will not be able to do a good mediation in this sector? Do you think so?
Yeah, Samirji, because as I told, if you have the knowledge of that business, you will have the conviction to decide. Now, if the geological objective is met, there is no point in drilling. अगर आपने ड्रिलिंग करके तेल ढूंढना था, एक पर्टिकुलर जगह आपने ड्रिल कर दिया और तेल नहीं मिला, तो देयर इज नो पॉइंट इन फर्दर गोइंग डाउन. और इस तरह के और भी जो पॉइंट्स थे, क्लियरेंसेस वगैरह, एंड देन सेस्मिक रिजल्ट्स के बारे में थे, तो उन सबको अगर टैकल करना है, तो अगर आप में नॉलेज है, तो certainly you will have the conviction to decide.
So because mediation is a voluntary act of the parties, unless both the parties agree, it will not happen. So do you think in these type of matters, both the party would agree or these things takes place?
Yeah, that is what I said. Out of 64 cases, where disputes are there, were there, half of them got resolved because of this. So both the parties consented, and then then they made payment, and the dispute got closed.
Okay. So thank you, Malikji. I was inquisitive to know this about for you, but we'll interact more. And as you see, we are collaborating and we are doing with IGMS, and we'll be meeting future very early. So,
Sure.
Kritika, over to you. You can proceed further. Yes.
So I would like to thank Mr. Malik for sharing your experience and valuable insight on mediation with all of us. Now I request Mr. Rastogi for his presentation.
Thank you, Kritika. Yeah. So, friends, today we are now on our sixth webinar of mediation, and we just heard experience of Yash Malik ji, who is a certified mediator, IICA certified mediator about oil and gas sector, and we'll speak to him more about during the webinar at the end of the webinar. So, the objective of this webinar is to sensitize the ecosystem about the mediation to uh, motivate professionals to look forward towards mediation and to spread information about the new Mediation Act 2023, which has come in last December last year. So we have done already 5 webinar and we have covered almost all the act. Today we would be uh, concentrating on some very interesting part of mediation, some case law, some relevant informations. And one of the most important thing in mediation is mediated settlement agreement. When the mediation is done, unless until it culminates in the agreement, so it succeeds only when there is a mediation settlement agreement. So we'll be talking more about a mediation settlement agreement. We have already spoken, but we'll give a recap and a detailed aspect on mediation settlement agreement. So let me share my presentation and we'll take it forward. I think my PPT is visible to all.
Yes, it is.
Yes, sir.
So friends, let's move forward then with today's webinar on mediation. So friends, as I said, we already have done 5 webinars prior to this, and we'll be carrying on this mission of doing webinars on mediation, and we'll be inviting various personalities, various experienced people like we have Mr. Yash Malik on these webinars to give various flavor of mediation to our audiences. So in previous webinars, what we have recapped, we have spoken about, it is just a recap of that. We spoke about mediation agreement, pre-litigation mediation. We also spoke about matters which are not fit for mediation. You have schedule 1 in first schedule in the Mediation Act 2023, which provides about what cannot be mediated. So like the which is a dispute related to deities or some government contracts and various other things which are there, something related to criminal activities, criminal offenses. So all those things were out of mediation. Schedule 1 described it in detail. So we dealt with appointment of mediator and commencement of mediation, conduct and role of mediator. So conduct and role of mediator is very basic backbone of the whole mediation process, and most of the professionals who want to enter into mediation practice would know and should know the conduct and role of a mediator. So we'll be doing a separate webinar on this, and we'll be inviting people to give their experiences on this subject. We also spoke about registration, enforcement, and challenge to MSC. So today we are going to detail on MSA. So we also spoke about non-settlement report, means once mediation is, if it is unsuccessful, then the mediator is required to file this report. We spoke about online mediation, termination of mediation, mediation counsel. That's an interesting thing which is provided in the act. Like most of you who are attending this webinar may be insolvency professionals, and as you have a regulating body called IBBI, which is regulating insolvency professionals. Similarly, in times to come, there will be a mediation council which will be regulating, or which will be framing rules for the mediators, the professional mediators who are enrolled, who are certified mediators. So there is a provision for mediation council. It is yet to be made. So whenever we come to know about it, we'll be mentioning it in our webinars. So MSP and its function. So this MSP is mediation service provider. There's a new category created, like in insolvency professional, you have IPE. Similarly, here we have mediation service provider. There is a provision of mediation service provider entity in the new act, and the same what IJMS is also aspiring to be India's leading mediation service provider entity. As soon as mediation council is formed and they open registration of MSPs, so India Juris will also endeavor to get registered at the earliest. So community mediation. So what about community? We discussed about community mediation. So these were the things which we have already dealt in our previous webinars. So friends, today we are going to speak in detail about the mediation settlement agreement, resolving disputes and restoring relationship. So this is the theme of today's webinar when we go forward. Resolving dispute. So as you all know that the mediation is a voluntary activity where both the parties arrive at a settlement which they want. It is not imposed by any third party. That's why we said it resolve the dispute. And when you voluntarily decide and agree on something, so obviously your relationship are restored. So that's why we are saying resolving disputes and restoring relationship. So friends, what is mediated settlement agreement? So it's a written agreement between parties out of mediation, settling disputes and authenticated by mediator. So as we have already seen in previous webinars, so whenever mediations take place, there is an agreement or there is a voluntary settlement between the parties. The mediator would facilitate those parties to come about or to achieve or to arrive at a solution which they want, that the solution should be of their problem. And once they arrive at a problem, there are a solution to their differences, their issues, that is written to reduced in writing, and then it is signed by both the parties. But the law provides that it has to be authenticated by the mediator as well. So once signed by the parties, authenticated by the mediator, then it becomes a mediated settlement agreement. So it can extend beyond the dispute initially referred to mediation. So what happens, friends, here's a little bit difference from arbitration. So, when you go arbitration is also a alternate dispute resolution mechanism. But in arbitration, where the dispute of references is made in the notice, so the arbitration is restricted to the references. But in mediation, it can go beyond. So it has more flexibility as far as arbitration is concerned. So whatever disputes are between the parties, they can resolve. It's not only what that was initially. So it must not be void under the Indian Contract Act. So it has to be, the agreement has to follow the Indian Contract Act requirements, which are very standard one. So in case of institutional mediation, it shall be submitted to mediator who authenticates and forwards to MSP. So when we talk about institutional mediation, there is a provisioning in the new act. Institutional mediation means one of the entity, like mediation service provider, who is conducting the mediation, is providing, who is conducting the mediation or facilitating both the parties to arrive in appointing a mediator and running the whole process of mediation. So the mediator will authenticate and forward to the MSP, and the MSP is registered mediation service provider, which is with the mediation council. So this is how, when agreement is entered into, first it is resolved by mediation, it is entered by the parties, authenticated by the mediator, and then it is forwarded to the MSP. So parties at any time during the mediation process may make an agreement. So it's not that when you are running a mediation that you can arrive at a settlement at any point of time. It's not that first I have to do a meeting, thereafter whenever at any stage you can arrive in at an agreement, and you can do a mediation settlement agreement. So it shall be in writing and signed by the, as we just said. In all other cases, it shall be submitted to mediator who authenticates and forward to the mediator service providers. So MSA includes those resulting from online mediation. So online mediation is because the Mediation Act 2023, one of the main objective is to facilitate online institutional mediation so that it is easy for other people to join, to take it forward, to engage in. It should be very cost effective, very saving a lot of time. So if any MSA is arising out of online mediation, so that is also included in mediated settlement agreements. So enforcement of MSA. So once the parties have signed, authenticated by the mediator, what happens then? The next question obviously comes whether this agreement is enforceable. How do I enforce this? So once mediation settlement agreement are signed by the parties and authenticated, then they are considered as final and binding. So this gives a more serious shape to the mediation process. So these agreements can be referred to and are to be enforced according to the CPC, and if they were judgments of decree passed by the court. It means once the MSA is signed, all parties have signed, mediator has authenticated, so it takes the force of a decree or a judgment, just like an arbitration award. So it is equivalent to that once it is signed. So parties or person claiming through them can rely on these agreements in legal proceedings. So MSAs can be used in legal proceedings. So that is another benefit. That is how you involve MSA in enforcement. So registration of MSA. So any agreement, order, whatever. So anybody would have a question in mind that whether can we do a registration of the MSA so that it becomes more authenticated and nobody retracts from these. So MSA. So what the law says, it is optional. If you want, you can get it registered, but it's not compulsory. So except those specific sources like court referred mediation and lok adalat, it can be optionally registered with a designated authority or a body with unique registration. So if you want, it's an optional. The point to note here is that if you want, you can get it registered with the designated authority and may be registered within the territorial jurisdiction of court or tribunal competent to decide. So wherever the dispute, whichever court is entitled to territorial jurisdiction of a particular dispute, then in that area you have to register it if you want to register it. So the registration process shall not affect the party's right to enforce or challenge the agreement. So whether you register it or not, it will not impact the rights of the parties. Okay, so that's why, because it is optional. So even if it is registered, it will not impact whether you register it or not, it will not impact the rights of the parties. Registration may be made by the parties or mediation service provider within 180 days. So if you want to get it registered, you can do it within 180 days after receiving the authenticated copy of the agreement. But that can be, you can do it later also by payment of extra fees. So that is the provision in the law. So normally if you see, so I am drawing a synergy here. If you see a Copyright Act in case of an IPR, so in copyright, the registration of copyright is not compulsory. Even without registering, if you are able to show that you are the first who did it, who made it, then the registration certificate is not. So registration in copyright is not compulsory to show your copyright on a particular thing. So similarly here, the registration is not compulsory, it's optional to derive your rights out of the mediation settlement agreement. Challenging MSA. So now we saw that MSA is signed, party have agreed, mediator has authenticated, we saw how it can be enforced, enforceability, we saw the registration process. Now, can somebody challenge MSA? So after MSA has been signed, what is the status on challenging the MSA? So either party can file an application to challenge the agreement in court, but there are very limited grounds to challenge. If you see in arbitration also, when arbitration award is passed, there are very limited ground. But here, it is a voluntary act because party have already consented to it. And then you cannot retract what you have agreed earlier. So there are very limited grounds on which the mediated settlement agreement can be challenged. And that is fraud, corruption, impersonation, mediation conducted in disputes not fit for mediation under such. So if it is through fraud, corruption, impersonation, or the subject matter was such which was the subject matter of a first schedule where it could not have been done by mediation, only in these limited four grounds the MSA can be challenged. Otherwise, the act does not permit any challenge. An application shall not be made after 90 days from receiving the copy of the MSA, and a 90-day extension may be granted if terminable. So if you want to challenge it, you have to challenge it within 90 days on the limited grounds which are mentioned here. You may get further extension of delay condoned of further 90 days if the tribunal or the court allows it. So we'll see in due course when the cases come in court that what is the practical aspects of condoning the delay and how much extension has been granted by the courts in the same. So mediation service provider, we just spoke about in the particular slide, in last slide. As I said, this particular act provides the creation of mediation service provider, which IJMS is trying to be. So if you see the mediation service provider includes body or organization that provides for the conduct of mediation recognized by the council. So now the bodies which are recognized by the council and they'll provide for the mediation. So they can be registered as, they would be termed as mediation service provider. And IJMS aspires to be one of the leading service providers. Functions of MSP. So friends, we dealt with mediation because what we are trying to cover in this webinar to sensitize about the settlement agreement and who are the main stakeholders who are dealing with this. So it gives a very broad picture about the mediation, who are involved and how it is done. Functions of MSP, mediation service provider, means what mediation service provider will do. In other words, I have to say what IJMS, when registered as an MSP, what IJMS will do. So accredit mediators and maintain panel of the mediators. So the MSP will have a panel of mediators empaneled with it. And whenever the mediation matters are coming, the experts will be allotted accordingly the mediation assignments. Provide the service of mediators for the conduct of mediation, offer all facilities, secretarial assistance, and infrastructure to ensure efficient conduct of mediation. So we already have offices all over India. So IJMS would be providing this all infrastructure and facilities to the panels empaneled and located out all over India. So we'll try to provide all these things. Promote professional and ethical conduct amongst mediator. Facilitate registration of MSAs. So you see, whatever is provided in the act for conducting the mediation or to taking it to a logical conclusion and to enforcing it, all support will be provided by the mediation service provider entities. So friends, now we just heard from Malik ji that when there were a lot of contracts, it took a lot of time for people, the authorities to decide. So now in case of an MSA, where government is one of the agency, then how the MSA is to be signed? Because we said that MSA has to be signed by both the parties, then authenticated by the mediator. So in most of the cases, the audience in here, the audience who are IP also, they would know that in COC, Committee of Creditors, where you have institutional members like banks or any other government agencies, the people, their representatives who are attending the COC, they do not have the full authority to decide or vote upon. So whenever there is a matter issued or matter dealt in the COC, so they would tell that we'll go back to the competent authority, get clarified consent, and then we'll vote upon it. And the process get delays because of that as well. So similarly here, in case of here the mediation settlement agreement, where the government is one of the parties shall, it means the people in the government who are there, who are doing in mediation, they can sign MSA only with the written prior approval from the competent authority before settling disputes, including commercial disputes through mediation or other ADR mechanism. So it means in case of mediation, wherever government parties are doing mediation, they would first require approval from their competent authority, whether they should sign MSA or not. So I think this would put things a little bit delay, but let's see how it works. So this was about all mediation service agreement, settlement agreement. So now other aspect of MSA. So the object of our webinar is to give flavor to the people who want to be in this mediation profession, then how things are developing. So all of you must have heard about the GIFT City. So now we are talking about the ADR mechanism with government establishing and how mediation is being, roped in those mechanisms. So the recently the International Financial Service Center Authority, which is in Gandhinagar, Gujarat, they have proposed establishing a ADR, Alternative Dispute Resolution Center at GIFT City. And what it will do, those who may not know or may know that GIFT City is dealing with mostly international matters, international investors, international dispute, international transactions. So there they are trying to establish ADRC, where it will provide a comprehensive framework for mediation, arbitration and conciliation, promoting IFSC as a dispute resolution hub. Now those who are mediator, who are certified mediator, who want to enter, they would see where the international level, like you hear about International Chamber of Commerce, International Arbitration, ICC Paris, and so many international agencies are there who are doing humongous amount of dispute resolution, and it's a huge revenue to any country, to any body. So that government of India is trying to get into GIFT City. So it will be developed as a resolution hub through by mediation, and if mediation is not doesn't agreed upon, then arbitration and conciliation. So that is proposed there. Objective is to include promoting IFSC's reputation, providing efficient dispute resolution. What it will do if the government is promoting mediation services in GIFT City, it will attract foreign investors, because what we are planning, we are hoping that a lot of foreign disputes may come in GIFT City for mediation settlement. So it will attract foreign investment, it will reduce litigation costs, increase investor confidence, job creation. So all these things are effort to, doing business, increasing the ease of doing business in India. And the mediation is playing a good role in that, and it's offering a very good role for in coming times to the mediators, to certified mediators and the professionals who participate in mediation. So what would be the challenges? Challenges include regulatory framework, the IFSC, the government, whatever framework they are making. So these are some of the challenges which they are facing, like market awareness, stakeholder encouragement. So these are all, we are also trying to do stakeholder encouragement through these webinars. So key features of ADRC, which Alternate Dispute Resolution Center, is proposed to be, created or to be activated at GIFT City. So it will be a autonomous governance under Companies Act, International Advisory Council, 10 to 15 global experts. This is what is proposed. Executive Council, Mediation Act, ensuring. So all those things are, lot many things are happening at higher level, at all levels the government of India is doing. So what are the key takeaways? ADRC to promote IFSC as a dispute resolution hub, autonomous governance and international advisory council, reduce litigation costs, job creation. So friends, you can see a lot of things are coming, and we all can have various kind of, we can see from each individual perspective what kind of role we can play in this growing market. So these are the recommendations which that committee has proposed. So collaborate to promote the services. So we would also, our IGMS, we also have, we are a regulated entity in GIFT City. So we are actively participating in trying to, take our ADR in GIFT City as well. So we'll be covering a lot of things from GIFT City, and we'll bringing it to our audiences about all the aspects from GIFT City in future. So friends, you saw that about mediation settlement agreement, about MSPs, and about GIFT City, what is the level and role of mediation is happening in on international level in India. Just to further sensitize and to bring about our audience that how the mediation is taking place, the court, how courts are giving indulgence to mediation. So for that, I have put here 2-3 case laws recent. So one is 2022 Bombay High Court case, which says, like we have a commercial court act, wherever there is any recovery, it has to be filed in commercial court act. And under section 12(8) provides a pre-litigation mediation. So what has happened in a case Why Not Films LLP and others versus Ultra Media and Entertainment, 2022 Bombay High Court judgment. So what had happened that there was an IPR suit which involved complex issues, expert opinion. So there was an IPR suit between these two parties, and the court has noted that the mediation can help reduce the burden on courts and facilitate a speedy resolution process. The Bombay High Court held that Section 12(a) of Commercial Court Act mandates pre-litigation mediation. So now the courts are pressing that first you go and do mediation. Whether it fails, that's a different thing. In commercial dispute, including IPR suits. So in conclusion, the Bombay High Court gave a ruling which promotes ADR resolution in IPR suits, potentially reduce litigation cost and timelines. Now you can see, friends, in this case also, the court has asked the parties to see whether you have gone to the mediation. Similarly, there's another case which is this 2024 Delhi High Court in Aditya Birla Fashion and Retail. So again, the Delhi High Court addressed the applicability of Section 12(a) of the Commercial Court Act, which mandates pre-institution mediation for commercial disputes. So all of you who are there, whenever there is a commercial dispute, now the courts are pressing you first go try the mediation. So the plaintiff Aditya Birla Fashion and Retail initiated legal proceedings against the defendant, Saroj Tandon, without undergoing the mandatory pre-institution mediation. So that was so Aditya Birla Fashion, they instituted the case, a legal proceeding against Saroj Tandon without going to the mandatory pre-institution mediation. So the party raised the counterclaim that they have not followed 12(a), a pre-mediation thing. So the court emphasized the importance of adhering to statutory requirement and dismissed the suit for non-compliance with pre-institution mediation mandate. So now you can see how the court is pushing. The machinery is pushing to mediation. And that is where the role of the mediators becomes very important. It's all of us to be more, activated, more little bit diligent about how the mediation is taking place. So I see a lot of things happening for mediators. So coming to the now, so this is again other story. It's been told. It's of 2000, but it is from the Yash Malik ji domain. It was an international boundary dispute mediation, Bulgaria oil pipeline dispute 2007. So now you see, in international context, where are the dispute between the countries, there also mediation is taking place. And now you can imagine how humongous the mediation process would be, how many people would have been involved, how many million of dollars of fees would have been involved. So there is lot many to do for the mediators. So the Burgas Alexandropolis oil pipeline project aimed to transport Russian oil from Bulgaria Black Sea port to Greece, reducing reliance on crowded Bosphorus Strait. So strait is a very thin, narrow river kind of place between the two part of land. So the project was jointly developed by Bulgaria, Greece, and Russia. So what had happened in 2007, there was disagreement between Bulgaria and Russia regarding ownership of the structure, transit fees, environmental concerns, route adjustment. Not many things were there, and there were a lot of differences and disagreements between these countries. So now what has happened? The Bulgaria sought greater control. So what Bulgaria wanted, they wanted a greater control and revenue, while Russia wanted to maintain dominance and minimize cost. Now it's an interesting thing to know about. What had happened then? So the International Court of Arbitrator facilitated mediation. Now you see the mediation took place in this matter. They conducted initial separate meetings. In mediation process, we'll deal with the whole mediation process in a separate webinar. So caucuses with each party were taken. Caucuses means when the mediator takes control of a proceeding, so he will speak to each of the parties separately. So when a mediator speaks to each party separately, that is called caucus. So the mediators have done separate party with Russian counterparts, with Bulgaria counterparts. The caucuses were done with the identified key issues and interests and stakeholders, facilitated joint sessions for open communication, assisted in proposal and counter proposal exchanges, encouraged creative solution finding. So these are the all activities which mediators are required to do, and they are required to develop such skills. Now you can see from a small matter where you are doing a community mediation, or for a small matter till you are doing a mediation between two countries. The skill set is same, but the scale is different. So what was the outcome of this? The revised ownership structure, Bulgaria gained greater control. It was out of the mediation. The revised ownership structure was developed. The transit fee which they were having, that was resolved. Environmental concerns were addressed. So route was also adjusted with binary accommodation. So this is what the mediation has done in this particular case, Bulgaria oil pipeline dispute 2007. Those who have further interest to know how the mediation played role, they may go on online and they'll find a lot of data on this. So benefit of the mediation, what the benefit was there? What was the benefit of that mediation? Like preserved relationship between Bulgaria, Greece, and Russia, avoided costly arbitration or litigation. So it was by mediation, I mean, ensure project continuation, maintaining regional energy security, demonstrating effectiveness of mediation in complex international energy disputes. So now you can see that what kind of benefit the mediation added in international kind of disputes. So I think with this, I am concluding my presentation on various aspects of mediation, and we'll keep sensitizing these issues. So over to you, Kritika. Thank you.
You have cleared all the mediation provisions, and in the last 5 webinars, you have completed all the legal solutions of the mediation.
So,
Yes, Kritika.
So, thank you, Mr. Rastogi, for this informative and interactive presentation. Through this presentation, we gain some deep knowledge on mediation settlement agreement, its enforcement, and challenges. Now, we would like to move to our panel discussion. So we would like to start our FAQs. My first question is to Mr. Sarvesh Kashyap. So, can we have your views on enforcement of mediation settlement agreement?
Kritika, I think I have no views because Samira already clarified all the issues. in last 5 webinars we have already clarified. But
But,
you know
but
that
Samir, we may have some new audience and participants. So this is a sensitizing webinar. So please give your views on that.
yes, yes, you know that for dispute resolution, mediation is preferred all over the world, as you just informed us now. So this is a very cost-effective, speedy, and confidential process. And I think this is one of the best alternate distribution process where parties settle their conflicts and mutual understanding with the help of a neutral person, which is called the mediator. And the mediation settlement agreement is nothing but a agreement between the parties to settle some or all disputes. And enforcement mechanism respect party autonomy by allowing the parties to define the terms of this agreement. So generally, Mediation Act grants legal recognitions to mediation settlement agreement, ensuring that they are enforceable in courts like a civil court decree. And courts are typically required to support and uphold mediation settlement. This judicial backing can improve the public perceptions of mediation as a mediable and confidential dispute resolution method. Yes, there are some challenges in enforcement. Challenges may arise regarding the interpretation, the application of terms in the agreement. Court may face difficulties in enforcing vague or poorly drafted items. Therefore, for effective enforcement mechanism, stakeholders, including judges, lawyers, and mediators, must be trained in the provisions of the Act, and increased awareness can lead to better understanding the interpretation of it. Yes,
So,
please.
Mr. Kashyap just spoke about mediation settlement agreement. So, Mr. Rastogi, what about the registration of MSA?
So I just spoke in my presentation about registration of MSA. So in short, I'll just tell that when we are talking about registration, so it's an optional. It can be it's an optional between the parties whether they want to get it registered or not. The main thing is where it is to be registered. It is to be registered where the jurisdiction in which the jurisdiction of the court to entertain that dispute is. So in that jurisdiction, if you want to register, you can register it, but it's optional. And when you register, whether you register or not, it will not alter or make your right any good or bad. So it's just an optional. If you want, you can get it registered. Yes.
So, moving to our next panelist, I would like to ask this to Malik sir. Sir, can a mediation agreement, maybe oral or exchange of emails, would amount to mediation agreement?
Mediation agreements have to be in writing under Section 4 of the Mediation Act. And there are some guidelines, like what all they will cover. I mean, although Mr. Samir has dealt in depth, but the points which get covered, I'll just give you a brief. The identification of the parties is done. The name and addresses are jotted down of all the disputing parties. Then defining the scope of the dispute. Then terms of settlement are there. That whatever disputes were there, how many got resolved, how many are pending, and what is the way forward. And then what will be the payment provision, or how will be the division of assets go through, or any other actionable item by parties under the settlement. Then, as Mr. Samir said, if you want to register it, then the governing law and the jurisdiction that will govern the interpretation and enforcement of agreement, that is defined. And finally, the signature of the parties and the mediator closes the agreement. Thank you.
Thank you, Mr. Malik.
I would like to add here one thing.
Yes, sir, sure, sir.
Yeah, we just saw about online institutional mediation. So when we are talking about online institutional mediation means things are happening online. So it means when the like we have to nowadays we have a system like DocuSign, other digitally signed document. We can sign a lot of documents digitally. So whenever the mediation is happening online, so in my view, the question was ki, whether it can be electronic. So in my view, it can be electronic and the parties can sign digitally. Otherwise, so that would otherwise the objective of online institutional mediation would fail. So in my view, when things are happening
Yeah,
online,
yeah, Samir, I think
yeah,
you're right, Samir, because I think the regulation is not framed now. So
ah,
after framing the regulation, this will be clarified.
yeah,
But definitely, in case of online mediation, digital signatures.
yes.
So, Mr. Rastogi, how the mediation settlement agreement gets authenticated in case of the institutional mediation?
Institutional mediation like MSP, the mediator has to authenticate. The law says the mediator has to authenticate it when the parties have signed it. Authentication. So the word used is authenticate in the law. It doesn't say sign or it doesn't say how it can authenticate the document. But from the very face of it, we say when we're talking about authentication by the mediator, so we are assuming the mediator has to sign it or uh, let's say it is authenticated by me, but I would assume that it is signed to authenticate. The mediator has to sign it, but more it how the authentication will take place, we have to wait for the guidelines rules coming out of the Mediation Act. But as of now, I could see that mediator would sign to authenticate it. And then on institutional mediation, then after authentication, he has to give it to the mediation service provider.
Yes.
And mediation service provider will take it forward how it has to be.
Thank you for this informative answer, sir. My next question is to Mr. Kashyap. So, as we have seen, as per the Act, anybody can appoint, the parties can appoint anybody as a mediator. So, when parties can appoint anybody as a mediator, to what extent a MSP or a registered mediator are relevant? Sir, your mic is mute. Can you unmute yourself?
Sorry, critical.
Yes, sir.
Yeah, because under the Mediation Act 2023, parties have the flexibility to appoint any individual as a mediator for their dispute resolution process. This means that the parties can choose anyone to whom they trust to mediate, whether the individual is not a registered mediator or not a member of a MSP. But registered mediator or MSP typically have formal training and expertise in mediation practice, which can enhance the effectiveness of the mediation process. They are often familiar with various techniques and strategies that can help to resolve disputes. Second, registered mediator has to follow certain ethical standards and guidelines established by the respective governing bodies. This can provide parties with confidence that the mediator will conduct the process fairly and impartially. Third, that is mediation service providers like India Juris Mediation Service can offer a structured framework for mediation, including access to resources, facilities, and administrative support, which can streamline the mediation process and make it more efficient. What is that if you engage a registered mediator or mediation service provider, they may provide an assurance of quality as they meet established standards. So trained professional and structured support can definitely enhance the mediation experience and outcome, but ultimately the decision with the parties, whether they choose a normal mediator or a certified.
So again, Kritika, I have something to add here.
Sure, sir.
Sarvesh said that it is really that the important that the registered mediators are equipped with a lot of skills, a lot of technical skills and knowledge and skills. But when you said what is the relevance when they can appoint themselves for a registered mediator. So what I see the relevance becomes when the mediator is not appointed by the parties themselves. Then when the third party is appointing a mediator, then which person should be appointed mediator? There comes the role of a registered mediator. For example, the parties approaches an MSP. So now when MSP has to decide to put whom the mediator, they cannot put any person. Then they are taking registered mediators. Parties, whenever the parties are agreeable, they can put anybody, they don't need registered mediator. But the once parties approaches MSP, then MSP, what is the standard for the MSP to have arbitrator? That is a certified mediators. When a court is appointing somebody as mediator, then court is taking certified mediators. So whenever the mediators are appointed other than the parties themselves, then I think registered mediator becomes more relevant.
Yes. Because the registered mediator have some techniques and strategy.
Yes. Thank you. Over to you.
Thank you both of you for this informative answer. So, this is the last question of today's webinar, which I would like to ask Mr. Malik. So, as per section 49 of this act, it has to be signed. This MSA has to be signed by the competent authority. So, till what extent it is feasible? Don't you think that it will delay the process? Like, would it impact the authentication?
So this is relation to Manikji, this is relation to the government contracts where the government is party. And I also wanted to ask this question too, where the government is party and the people have to go to competent authority to sign the MSA. So would it not further delay the process? So I think Malikji
Yeah,
Some
he's.
technical problem.
disconnected here.
So, Mr. Rastogi, can you please share your views on this?
Because being an RP also, I have seen a lot of resolution processes where CIRP is going and we are doing a lot of COC meetings. And we see that the government bodies or the financial PSUs, they are unable to decide. And they have to go back to the competent authority and which takes months to decide upon. And I foresee that this thing may happen here as well. In taking for signing an MSA when they have to go to back to the competent authority, it will take longer time. It may delay the process. But at the same time, this is necessary to stop the malpractice also. So there has to be a balance of it, and we see how it goes further. But I'm sure it would take some delay. It would make the process little bit delayed.
This,
Yeah.
this is the common problem of all RPs.
Yeah.
And definitely, in new act will consider our request that such kind of situation should go together.
Yes. Yeah.
So,
So,
we come. Yes, sir.
yes.
So,
Am I audible?
yes, sir, you're audible.
Okay, I'll just add my few cents here. Section 49, you have to take for all commercial disputes approval from competent authority in the government. So this competent authority is, matter of one's belief. The case which I had referred to earlier, bureaucratic delays are always there. I mean, the systems are not that efficient. Now, you see, in a normal case, in any single case, a competent authority could be the secretary or the minister of any ministry. But but when it comes to any um, thing in principle requirement or anything of very high value, then it is sent to ECS. ECS is the you know committee of secretaries, secretary finance, legal, expenditure concerned ministry. So when it goes there, it takes at least 6 months. Now, although the act says that you have to decide in 4 months, so I'm sure going forward, once things are brought under the Mediation Act, I'm sure there will be some more efficiencies, and also the awareness of Mediation Act is not there. So slowly, once it builds up, it will improve things.
So, sir, somewhere it is delaying the process.
Definitely, it is delaying the process, because in private you can decide in 1 month maximum, or 45 days. Any board can decide, but here it takes. Presently, in our case, it took about 6 months.
So, have you encountered like any case like this?
Yeah, that is what I'm saying. The only one case which is there, where that CEEE was formed. They Once they made the recommendation, and then the recommendations were to be approved by the government before they were to be signed. So this whole process of approval took about 6 months.
Okay, sir. So we come to the conclusion of our webinar. So I would like to thank Mr. Rastogi, Mr. Sarvesh Kashyap, and Mr. Malik. I would like to extend my thanks on behalf of IGMS to Mr. Malik, Mr. Kashyap, and Mr. Rastogi for enlightening the participants. And I would like to thank the participant who spared their precious time and listened to the speakers. And I hope they have resolved their queries as well as they have gained clarity on the practical aspects of mediation and mediation settlement agreement. So thank you so much for your time and presence. Thank you all.
Thank you very much. So
Thank
we'll
you.
come in
Thank
the
you.
next webinar. We'll be bringing out some other sector and we'll try to have more interesting knowledge to share. Thank you very much. Thank you all of you.
Thank you. Thank you. Thank you.
Thank you, Malikji. Thank you, Malikji. We'll meet
Thank you, sir.
sometime shortly.
Yes, sir. Sure, sure.
Yeah. Thank you very much.
Hi.
As India Juris, we aim to be the best place for the lawyers to work in and set up standards for the lawyers to develop their skills being in this law firm. We aim to provide high standard of international legal services to our international, global and domestic clients.
India Juris is having innovative strategies with regard to intellectual property rights disputes as well as international dispute resolution. And we are having a lot of milestones which we have achieved and about to achieve.
At India Juris, as a full-fledged law firm, we are advising corporates, startups for their advice on IPOs and further transactional matters.